Hello, everyone. I'm Jay Lazega. Welcome to this session of Lazega Johanson's Morning Break. We're glad you're here. Thanks so much for joining us. We love doing these. We hope you're enjoying them. Hope you're visiting us on our website at ljlaw.com in the resources section. We've got our videos up. This should be up early next week. We've got sample documents. You guys know we like to give you things that are useful and practical, and we will have one today. It's available in your sidebar if you look in the document section, attachment section. And Taylor's going to talk about that later. We appreciate all the positive comments from you guys, so keep those up. If you have questions today or comments, you could use the question section in your sidebar. We won't be answering them in this section, but we'll get back to everybody individually. We have another session on COVID-related issues. I think everybody, we all hope that we are in the next phase, the looking forward phase of largely getting out of the COVID issues and back to some semblance of what our next life will look like. We're going to talk about those issues today. Georgia is, interestingly, the outlier or the unique state that's not seeing an uptick in cases after all of our relaxation of guidelines. But we'll talk about that. We're all hoping or waiting to see if Governor Kemp issues any additional orders or extensions or information, or the Georgia Supreme Court does. A lot of things are set to expire soon, and we'll talk about that. But we have with us today Rob Stein, Taylor Mathis, Jericho Phillips. We're going to talk about COVID issues, and thank you guys for joining us. Rob, up to you.
Jay, thank you, and good morning, everybody, and we hope everybody's well. One of the frequent calls that you've told us you're getting, and ones that we're getting as well, are members reaching out to the board to say, hey, there's that swim tennis down the street and it's open and we're not. They're yelling, everybody's open, but we're not. Why aren't we open? Well, the reality is, and we've done some informal reaching out to a lot of you guys to help us with some numbers, is that it's probably 1 in 3 that is open. I talked with one management company who 10% of their communities had opened, 46% in another, 50% in another, and a large pool company said 20% of their pools had opened. So we'd throw a number of probably 1 in 3. Those remaining closed, even those remaining open, are really waiting for Governor Kemp's current executive order to expire, which it will Monday evening at midnight. But the question is, will we see later today or tomorrow a new action by Governor Kemp, a new executive order, which extends the restrictions and mandates that he has in his current order, where he reduces them, steps them down some, or where he otherwise lets his order expire and it's we're back to well, where are we back to? Because we would expect the Georgia Department of Public Health to take action and give new guidance in accordance with wherever the governor goes, but we'll still have the CDC guidelines. I'll have to take those into account as we look at to what to do next, because the pandemic is certainly not over, though we hope it's beginning to wind down. So with the pressure that folks are under, we thought it best to quickly recap where we are. And we are, as a group, as a community association world, in a sense, in a place we really haven't been at before. From an insurance standpoint, we have a prime issue in front of us where associations have no coverage. In the past, and where we had a slip and fall, we had somebody cut their foot in the bottom of the pool, we have insurance coverage for that. We now have the unique place, the unusual place, not a very comfortable place for board members, of being in a place where we don't have insurance coverage for claims that arise as to COVID, and that's just to most of the carriers that we've heard and seen. So if claims arise, associations will be on their own. They're going to need to come up with the funds from the Treasury and other assessments, perhaps, to defend these claims. So we do have folks that are opening, and our guidance has been to, is to really be cautious and careful, because without liability coverage, without appropriate insurance coverage, you're seriously at risk. But those are opening, hopefully, and we see many of them, most of them are taking the right actions. They are doing things, and let's kind of walk through what you need to be doing. If you're opening, you want to open probably for a test weekend or a test couple of days, and tell your owners you're doing that so that they can, so you can test the new things that are out there. What you're supposed to be doing as far as social distance monitoring, cleaning and sanitizing, and so forth, and seeing if the actions you put into place are working, and if your members are being cooperative, because if they're not being cooperative, that could be a reason for pullback. Hopefully, you've posted signage which required by the governor Kemp's mandates, and those recommended by the Department of Public Health and the CDC. Two main cost and functional challenges that every community is facing, and those that have opened are working with, the first one is social distancing. Boards are telling owners, or should be telling owners, that we're going to have reduced capacity at the pool because we've got to create spaces for social distancing. That's the right way to do it. Create grids on the pool deck. Use duct tape. I've seen big X's marking the spot. I've seen maps that coexist with those, so that owners know when they make a reservation system is really the right way to go about it, that they have spot number 12 and they have it from 1 to 3 on Saturday. And to use that to help with social distancing amongst various groups. Again, we don't want to have any guests. The recommendation from public health and the CDC is not have guests, because that by having guests, you create further opportunities for spreading the virus. Hiring the pool monitor. Governor Kemp's order looks for nonprofit corporations to enforce social distancing. The Department of Public Health's guidance is you need to hire a pool monitor to enforce that social. You don't have to hire someone, but it could be a committee. It should be adults. It should be someone of responsible age who can take care of these responsibilities. Second big task, cleaning and sanitizing. We've recommended that you hire an outside company to do this. Now in COVID world, we have some new terminology that perhaps you've gotten used to. One is shared objects, the other is frequently touched surfaces. Shared objects are those things where somebody makes use of it on a more personal basis, like a lounge chair, a kickboard, a pool noodle, where they're using it for a while and having personal use of it. As a now falling in this category of shared object, it has to be cleaned and sanitized before the next person has use of it. And that's the obligation of the owner of the facility, the association. The other thing the other categories, frequently touched surfaces. Examples of these are gates and door handles, hand washing stations, handrails, restrooms are all frequently touched surfaces. The requirements, the governor's order said that there should be cleaning and sanitizing as appropriate. The Department of Public Health divided things in these two worlds, as has the CDC. For frequently touched surfaces, the requirement is to clean before the pool is open, at least once during the time it's open, and more frequently depending on the frequency of use. So the next thing, as I kind of wind down here, is that a lot of communities are making use of waivers, releases, and these are designed to try to sweep in as much as possible, but not everything is possible to be released. And they are not bulletproof, and they themselves could be the subject of a litigation about their enforcement, as to adults and as to minors. So are they helpful? Yes. Do they help reduce the number of claims that might come up? Yes, but they are not bulletproof. Lastly, on the flip side of all this is the closing of pools. Most declarations have the right in it to close the amenities on a limited basis or for emergencies, and we're certainly in a time where both of those can apply. If your declaration has less than that, we can help you by taking a look at it to see, but you typically under the business judgment rules and regulations and various things that, where we're talking about the public health, safety, and welfare of our residents, we can probably find decent authority to close it on a short-term basis while things move forward. And with that, I'm going to turn things over to Jericho, who's going to talk about where our courts stand at the moment. Jericho?
Thank you, Rob. As Rob said, I'm Jerica Phillips. I'm a litigator here at Lazega Johanson. I'm going to be speaking about the order that the Supreme Court issued back in March. On March 14th, as you're probably aware, Chief Justice Melton issued the order declaring a statewide judicial emergency. That order was subsequently extended twice, and under the current order of judicial emergency, it has been extended to June 12th of 2020 at 11:59 p.m. So that is tomorrow night, basically. And so after tomorrow, all of the deadlines that have been told, stayed, modified will be reimposed on all actions that are in the Georgia court systems. So what that means for associations, if you have pending litigation that was filed before March 14th, filed and served, any of the response times that were set back on March 14th, those response times are going to resume, and you're going to have the exact same amount of time after June 12th, well, starting on June 13th, basically, to do whatever was needed in that case. So for example, if the association filed a claim against a homeowner before March 14th and that homeowner was served on March 4th, that would be 10 days before the judicial emergency started. That homeowner would still have 20 more days after June 12th to respond to that answer, because every defendant has 30 days to respond to an answer. And so when the judicial emergency took place on March 14th, that homeowner still had 20 days to respond. So that's going to be tacked on. June 13th, we'll have 20 days to respond. Also, if your complaint was served during March 14th to June 12th, 2020, all of the response times have been told until June 13th. So if a complaint was served between March 14th and June 12th, you still have, the homeowner would have 30 days to respond after June 12th. And so if the association was sued during that time period, the association also has 30 days to respond. And that deadline isn't only for responding to answers and things like that. That includes answering discovery or any court-ordered response. Those have all been told. Also, under the second order, there was some leeway with some judges to reimpose some of those deadlines. So some of your cases may have different deadlines, and that would be pursuant to a scheduling order that the second judicial emergency order allowed judges to do. With the tolling for the past approximately 3 months, we have seen a backlog in the cases that are on the court's dockets, and we've noticed that the courts and judges are very motivated to get those dockets and cases moving forward. And so we have noticed judges will not be allowing extensions or anything like that outside of what we already have had with the tolling of the deadlines. So we're going to have to be very proactive in getting all of our cases filed and moving so we avoid getting pushed back in this backlog that's already been created. Lastly, under the second order of judicial emergency, there were further instructions given on how to conduct video hearings so that the cases can move forward and we can push forward our litigation. And under that order, it's important for you guys to know that when you are going to be giving testimony in a video hearing, you have to have both a camera and a microphone. So because the judge needs to see and hear you. So you can't just call into the Zoom or the WebEx. So make sure that you get your setup ready for any hearings that are coming up. We've noticed that we're getting very short notices with these Zoom hearings. I've got a notice that was 2 weeks. So we got it the Friday before, and we had to be ready for the hearing in 2 weeks. So make sure you're getting your setup ready and you're ready to go with the video conferencing. But other than that, that's all I have. And next up is Taylor.
Awesome. Thank you, Jericho. So for our final topic, we will be revisiting something that we touched on last week's morning break, and that is how to respond to owner demands for refunds and reduced assessments. And we know that we've been getting these requests. We know you guys have been getting these requests. They're offensive, but we want to give you guys some tools and some guidance on how to respond when we do get these questions. So first of all, an owner's obligation to pay assessments is a legal obligation that they have that is entirely independent from an association's obligation to provide services. And this is not only the case in Georgia law, it's also written into the Georgia Condominium Act and the POA Act. So just because an association has temporarily closed an amenity does not give an owner any legal right to reduced assessments or refunds. Now that said, like Rob mentioned, most community documents actually authorize boards explicitly to close amenities either temporarily or permanently. And so that fact does not give an owner a legal right to a refund or obligation. So then the next question becomes, well, should we give them a refund or reduced assessment, particularly where we have amenities either closed for the season or we've had a delayed opening? And our answer is no. First of all, a budget is just what it sounds like. It's a budget of projected expenses. And so just because we may be saving a bit on our pool budget or on our budget for any one amenity does not mean that we should be giving that money back, because it may need to be allocated to other things in our budget that were not anticipated. The best example is COVID-19. When a majority of the 2020 budgets were being created, we were not anticipating any additional expenses with COVID-19. And so we need that surplus to the extent that there is some to make up for those new expenses, like monitoring social distancing, or even cleaning up common areas, additional sanitization, and things like that. The next reason is if we have our amenities closed right now and that's our plan, we might change our plan later on in the summer. We want to be able to have those funds earmarked for those additional expenses. So if we do end up deciding to open, it's better to have that money in our back pocket than potentially giving it back to the owners only to ask for it back later. Or if some other expense that was not anticipated comes up during the year, we want to be able to have money for that. The next thing is even if something like the pool is closed for the season or temporarily closed, that doesn't mean that the association has the major windfall of cash by any means. A lot of the expenses associated with operating and maintaining a pool or other amenities are still in place and still in effect, and things like general maintenance, repairs, those line items are still part of the budget. And so the actual surplus may not be as great as these owners think. Now that said, what I recommend and what we recommend is if owners are looking for answers, they're looking for refunds, reduced assessments, and they're not satisfied with those answers, I think it makes sense to tell them that, to the extent that there is a major surplus this year where an association has massive savings and they're able to put that money into their reserves, perhaps that board can revisit their budget and make some potential reductions for 2021. And to the extent that that's possible, we can definitely consider that, but that allows us to acknowledge the owner's requests while still being able to hold on to those assessment amounts that we really need. And so to that extent, we've prepared a sample response letter. It's attached to the webinar as a handout, and we will also be posting it on the resources page of our website. And the letter basically sums up the general points that I went over here. It gives you guys a guide for preparing responses to individual owners, and there's different places for you to customize for your different communities. Feel free to use it for all of your communities. You'll see at the bottom of the letter, there are some different sentences and brackets for you to put in specific information about your community's amenities. So for example, if you close the fitness center for the season or until further notice, but you're opening up the pool or you're keeping the playground closed, there's different language in there for you to mix and match as it makes sense for you guys. And of course, if you have any questions about that or anything else related to these requests, feel free to reach out to us. But with that, I'll give it back to Jay.
Great, thank you guys. That was great, very helpful. So a few closing notes, the resources section on our website, definitely feel free to use those, share those with your boards. Some great materials there, waiver forms, letters like we've discussed here. Of course, they're not specific advice to any community, but we think they'll be really helpful for you. So we encourage you to use those. We also have, like you, struggled with this period of court closings, court delays. Jericho discussed. There have been some challenges with that. We all are waiting for garnishment checks out of all of the counties, and we know there's a lot of money for communities sitting out there. Hopefully those get processed soon. But on a positive note, we really hope this idea of video court hearings takes. We know how disruptive it is to you guys to have to go down to court and be witnesses. And if the future is us being able to do all of that by video, we will all be very happy. So we're watching for that. And then we hope you join us next week. One of the things we're starting to see, whether you've already opened amenities and you're starting to wonder about this, or whether you're about to and you will see these issues soon. But one of the things we're seeing is we will likely have this obligation to continue to socially distance for a while at our amenities, even with the expiration of orders that we expect are coming. It'll probably be the norm for our communities. And we know that's challenging, with monitors often being, young adults and having to monitor social distancing among other young adults. That's challenging. So a lot of boards are beginning to wonder, can we maybe be more flexible in changing some of our age requirements and supervision requirements at our amenities? Really significant question, big legal issue. That's going to be one of the things we discuss in our next session. So we hope you join us for that. We love to hear your comments, your feedback, so please let us know. And we miss you guys. Stay safe.